24CV001325. I'll note for the record that this hearing is taking place by video conference, and that I have invited the attorneys to appear remotely, and I'm going to ask them now to make announcements of their presence, starting with counsel for the plaintiff.
Good afternoon, Judge Ashley and John Merchant, on behalf of the Merchant Law Firm. Also appearing is our paralegal, Sierra Bergdorf. She is in one of those boxes, and she's here for purposes of documents and screen share. And then I would note the two of the witnesses, Ryan Holmes and Andrea Geiger, are both witnesses from Critical Mention Media Company. I don't believe we're going to need them, so I'm fine keeping them on this main page for a few minutes. We have business records from them that we have already introduced with business certificates. I just had them here just out of an abundance of caution in case the state had any objections or questions about those business records. But if they don't, and we can admit those, then those two folks can be excused.
Okay, let me get announcements from counsel for the various defendants, and then I'll inquire about your proposal.
Good afternoon, Your Honor. It's Sandy Monroe here on behalf of the Fulton County, the District Attorney's Office, Bonnie Willis in her individual capacity, and Bonnie Willis in her official capacity. Also with me is Brad Bowman, my supervisor, who is going to be my second chair in this matter.
Okay. Did you say Mr. Bowman?
Correct. Brad.
Okay. Bowman. Thank you. Okay. So to start with, Ms. Monroe, I think I understood. I know there was I saw some email traffic regarding the parties' disagreements about whether people could submit certificates. But to start with the first question, Ms. Merchant has indicated that Mr. Holmes and Ms. Geiger are present here as witnesses of the company Critical Mention, and she has also submitted a certificate regarding those records. And I think I understood Ms. Merchant's proposal to be that if the county, to be clear, if the defendants are okay with accepting that business records certification, then Ms. Geiger and Mr. Holmes could be excused. What is your position on that, Ms. Monroe?
I don't believe I've ever received certifications. Were they each filed on Odyssey?
Yes.
Okay. I haven't taken a look at those records. It wasn't my understanding that there were subpoenas from those members, so our office would have to take a look at them to determine whether or not we object. But assuming and this is just for emails.
So on September 4th, the plaintiff filed a notice of intent to introduce business records. It's docket number 66. And I believe those, let me pull them up to make sure I'm referencing the right document. But those are a notice of intent by the plaintiff to introduce business records, and they are business records that carry a certification signed by Andrea Geiger as the Senior Director of Sales and Training for Onclusive Inc., which I assume is the Critical Mention company that I've heard of before. So those are the documents, I think. Ms. Merchant, is that correct, or is there something else?
No, that is correct, Judge. And we actually gave those documents before that. We gave them to the state, to the county. We sent them by the court's deadline on Tuesday at 2 o'clock. We sent them a link with those documents included. They're Bates labeled, and they're attached to that, as well as the business certificate was sent that day as well.
Okay. And so, Ms. Monroe, understanding that you might want to the extent that we're going to discuss those documents in detail at some point, at any point, if it's necessary, I understand you might want to reserve any objections about the fact that you've only had some time to look at them substantively. But in terms of their authentication and their admissibility as a business record, which is really just the limited question right now, do you have any objection to accepting those documents as being an authentic business record of Onclusive, so that we can excuse Mr. Holmes and Ms. Geiger, or do you wish to have them wait in the breakout room with the other witnesses?
No objection, Your Honor.
Okay. So the record will reflect that the defendant's counsel has graciously agreed to accept that business record certification for the records from Onclusive. And I believe with that, Ms. Geiger and Mr. Holmes, you may both be excused. Thank you for your time.
Thank you.
Thank you.
And Judge, we would invoke the rule of sequestration. Dexter Bond is on the screen. He is one of our witnesses. And then we've got quite a few other witnesses I don't see on the screen, so I'm not sure if they're in the county attorney's office or where they're sequestered. But I just want to make sure they're not watching on YouTube or anything like that.
Right. So I do see that Mr. Bond is present, and I do have him listed on at least a notice of filing subpoenas that was submitted by the plaintiff. And so now that the rule of sequestration has been invoked, Mr. Bond, we do have a breakout room. So it's sort of your choice. You can log out or you can just wait in the breakout room. And if and when you are needed, you will be invited back, or the county attorneys will tell you to log back on. But Ms. Merchant's point is a valid one, that to the extent there's anyone who is observing these proceedings online or through YouTube, if you are a witness or potential witness in this case, then the rule of sequestration has been invoked and you need to stop watching any live stream that you may be watching or any Zoom link that you are watching in order to comply with that obligation. I see that Mr. Bond has left us. And again, I'll just ask the parties, for those of you, you know the names of your witnesses better than I do. If you see someone pop up, let me know and we will invite them to either log out or go to the breakout room. Okay, so what we are actually here on today is the Merchant Law Firm filed a complaint alleging a violation of the Georgia Open Records Act. Based on a request that the Merchant Law Firm submitted to the Fulton County District Attorney's Office, using, I think, what's alleged in the complaint is a portal that is provided by online to submit such requests. And then at some point, there was a question as to whether the quote Fulton County District Attorney's Office end quote was an entity. I think that was a concern that was raised by the defense at the outset. And so at some point during the process of this case, the Merchant Law Firm added Fulton County, Georgia as a defendant in the Open Records Act case. And then subsequently, with leave of court, after a hearing that we had regarding who was the appropriate party for such an Open Records Act, the court granted leave for the Merchant Law Firm to add Fonnie Willis individually and Fonnie Willis in her official capacity as, of course, the district attorney of the Fulton County. So that's where we are now. At the hearing where where we had this initial discussion, part of that conversation revolved around the fact that, to my way of thinking, there was a way to request records from Fulton County or from the district attorney's office in whatever manner we're going to call that entity or that individual. And therefore that necessarily indicated that there must be an appropriate party to pursue remedies against to enforce the right to get those records. And that it was really just a matter of figuring out who that right person was. And I think initially, and in fairness to Ms. Monroe, I think it was an informal request, albeit one that was in court, in answer to a question of mine. If the Fulton County District Attorney's Office isn't the right party, if Fulton County isn't the right party, then who is? And then there was a discussion of the fact that it was maybe the DA, either individually or in her official capacity. And then there was some additional discussion about the fact that there is currently a Supreme Court case pending regarding the district attorney, who I believe is named in an individual capacity, on an Open Records Act request in Athens, Clarke County, that is before the Supreme Court and that has already had hearings where amicus briefs were filed. And yet, sadly, we do not have the benefit of the court's ruling today. So that's where we are. In terms of the operative complaint currently is the second amended complaint that was filed on July the 22nd. And then in response to that, the all four entities or individuals, depending on how we're going to call them, have filed motions to dismiss. Generally speaking, what I understand the basis of those motions to be is that as to the Fulton County District Attorney's Office, the position has always been that the Fulton County District Attorney's Office is not an entity that is capable of being sued. As to the County of Fulton, that the county isn't the custodian of the records that are being sought, and the county, and that records were never requested from Fulton County. As to the district attorney individually, I believe, if I understand, and I think that's what we're going to spend some of our time dealing with today. The basis of the motion to dismiss is that the district attorney did not handle those requests and is not an agency for purposes of the Open Records Act, and or that she is not subject to the act because of her official status as an officer of the judicial branch, and that she is immune from suit as a district attorney. That's a very, very shorthanded way, but just the reason I'm outlining those things is I like to start with, this is what I think I understand about where we are in this case. I've read the briefing, so you don't have to reinvent the wheel for me. And I agree with the parties in some of the email cross traffic that I saw that we have to figure out what to do with the motion to dismiss before we figure out what to do about the substantive requests, because the backup defense or basis for a dismissal filed by each of the defendants is, and even if you decide that somebody is subject to the Open Records Act and must produce the records that were requested, all the records that are responsive have been produced. And so that's where I think I'm going to, at this point, throw it over to Ms. Monroe to outline and make her argument for me regarding the basis of the motion to dismiss. My hope is, because I think we have a lot to get through, I'm trying to let you know that I have read your brief, so you don't necessarily have to go back and start at the very beginning, because I know there's a lot that goes in to getting us to where we are now. So if I've said anything wrong, Ms. Monroe, please feel free to correct me to make sure I have the right information. And of course, please feel free to educate me about anything I have not addressed that you think is relevant to my consideration. And with that, I will toss it over to Ms. Monroe.
Thank you so much, Your Honor. That was a pretty good outline of the issues before the court. And with just one correction, the matter that's pending in Georgia Supreme Court, where we're awaiting a decision, is not whether or not Fonnie Willis in her individual capacity is subject to the Open Records Act, but whether in her official capacity that she's subject to the Open Records Act.
Well, I agree with that. I think the only reason I mentioned it is that it is less than clear in some of the briefing that I've seen as to whether the actual underlying request that was submitted to for Open Records was directed to Deborah Gonzalez, or if it was directed to the district attorney of Athens Clarke County, Deborah Gonzalez. That's the only reason I mentioned it.
Understood. Thank you so much, Your Honor, for that clarification. So I have a brief update for the court and we're ready to move forward on the motions to dismiss and address to the court the procedural defects in the complaint and the reason why we're bringing the motions to dismiss. But the brief update is that this case has been deeply rooted in the alleged failure to provide documents or attachments to emails linked to critical mention. However, the attachments were provided 9 months ago. And as of yesterday, we learned that it wasn't an issue of providing those attachments. It was an issue of whether or not the requester had the ability to access the attachments. So basically she did.
So yeah, forgive me for interrupting. Let me ask you this. So I did see a recent filing. I don't off the top of my head know who it was from, that said something to the effect of, we're sorry, we're only providing these documents now, but we only recently learned that there was some software we had to download that would enable us to access. Is that what you're talking about?
Yes, that's exactly what I'm talking about. this software that, this filing was not made by me, it was made by the merchant law firm.
Mhm.
And this software that was described was Adobe Acrobat. I received several emails from the merchant law firm alleging that we did not provide attachments and that they insisted that we provide attachments to the emails. I found it very, very strange that as of yesterday, they still weren't able to access these attachments. And so I provided some direction and I advised her to download these documents on Adobe Acrobat. That's how I've been doing it. That's how I've dealt with all my PDF documents. And the response from the merchant law firm was essentially pure blame on our office for not advising them of this special software to open up these attachments. So what we have here before you, Judge, is a case that, Your Honor, there's something left to do. We provided the records 9 months ago with those attachments. I don't work in IT, but it's very likely that 9 months ago, the merchant law firm had this very same issue and they were not able to access those records. That's the reason why we're here today. In every instance that the requests were made by the plaintiff, response were provided. Where responses were not available, that was indicated to the requester. If additional time was needed, that was requested. There are no further documents within our client's possession that would be responsive to any of the open record requests. Thus, the court is in no position to do anything further for the plaintiff. They have their records. There's nothing left for us to do. Now, we do have this pending decision before Georgia Supreme Court. And it would be our recommendation, being that now the plaintiff has their records, there's no prejudice to the plaintiff in waiting for that decision, because that decision serves as the foundation as to whether or not we can even move forward on a hearing on the alleged merits of this case. So at this juncture, the matter is moot. There are, according to plaintiff's email, there are about 4 outstanding open records requests that, in my review of the responses by the DA's office, there are no responsive records. So as far as what we can do right now, there's nothing we can do. The Open Records Act was not designed for the creation of documents non-existent at the time of the request. These documents would have to have existed. These documents would have to have been searched diligently, reasonable search. These documents would have to have been in the possession of the custodian of those records. And in this case, we have a situation where all of those standards have been met, and there's nothing to do for it further in this matter.
Okay. So let me ask a couple of questions. So I agree with you generally that there is, it might be advisable for the court to, again, decline to decide this legal issue while I await the Supreme Court's decision. You know, I don't know when that might come. The Supreme Court had 2 Open Records Act cases on their docket this session. They issued one ruling on August the 13th, but they have not issued the one regarding the applicability of the Open Records Act to a district attorney. So that's one issue, but what I hear you, but when you say it's moot, I think you're understanding, I think, let me make sure I understand what you are saying, which is that you have fully responded to the requests. And so there's no need for the court to go further. I should just dismiss because the Open Records Act has been fully responded to. Is that essentially the defendant's positions?
Correct, Your Honor.
Okay, which defendant?
So, and that's the second issue. We need to determine the proper defendant in this action. And with the pending motions to dismiss in this action, I don't believe we have one. And so that is
Well,
where we are.
Ms. Monroe, that's why I asked the question, right? So I appreciate that the ideal answer to an Open Records Act request is here are the records you have requested, or we've searched and we don't have the records you have requested. But I don't think that we can have it both ways, where some nebulous defendant that isn't identified has given all the documents that have been requested, but you can't identify which defendant that is, right? And that's why I'm confused. Is it Fulton County that produced the records? Is it the Fulton County District Attorney's Office that produced the records? Is it Madam DA that produced the records?
Okay, so back in January when the original, there were, in this action, there are about 13 open record requests.
Right.
Okay, so the ones in question, we narrowed them down to about 4 at this
Which
point.
I greatly appreciate. Thank you both for that effort, because it was greatly to my benefit.
So as it pertains to the critical mention records, there were records that were provided back in January. And there was subsequent communication between the DA's office. The request was firstly made to the DA's office. Okay, and there was communication thereafter between the DA's office and the merchant firm regarding attachments to those emails. Emails were provided. However, the allegation was that the attachments to the emails were not provided. Fast forward, we're in suit. And the same allegation remains that we did not provide attachments to those emails.
No, Ms. Monroe, to be clear, I absolutely understand your position that
Yeah.
you have, that all of the documents requested have been produced.
Okay,
But that begs the question, by whom?
so initially we had the custodian for district attorney provide records. And then 16 subpoenas were issued by the merchant firm for this, the same subpoena to about 16 individuals requesting these same records. Similar records, not the exact records, but similar. The subpoena was a bit more detailed. And included lists of emailed individuals that worked for IT, that worked for the DA's office, that worked for external affairs. It was a bit more detailed, but those subpoenas, those responses to those subpoenas were provided by IT, Fulton County IT.
Okay.
However, what should be noted by the court is that the subject open record requests, the open record requests that are pending before this court in this underlying action, there were no requests made to Fulton County IT. Thus, we don't have any liability under the Open Records Act as it pertains to Fulton County or Fulton County IT. These requests were made to the DA's office. They were not made to Fulton County IT. So ultimately, there were additional records that were provided by way of the subpoena. And those additional records, those supplemental records, were provided by Fulton County IT.
So I understand that we're technically here on a 12B6, but because of the way the Open Records Act penalties and enforcement actions work, it's a little broader than that. And so one question I do have, Ms. Monroe, and perhaps you could help me understand. I know we discussed it at the last hearing, but the Open Records Act portal, where requests are submitted, it is I guess, a button that's present on the Fulton County District Attorney's Office's webpage, which is functionally, I guess, a subset of the Fulton County website. And when you click on that Open Records Act request, it goes to a Fulton County, a sort of generic request records from the county. So if I'm doing that, which I believe Ms. Merchant's pleadings have alleged that that's what she did, Or if not, she has represented to me, I think in the previous hearing, that those requests were made through the portal. How does the county IT department, whoever is in charge of that portal, how does the county know where to submit that request, to whom to direct that request?
So that's a great question. So generally when an open records request is submitted on the portal, you have to designate or select the department in which you're directing that open request to. That is how that works. So it's just not Fulton, it doesn't go Fulton County and that's it. You have to designate a department. You have to specifically select a department in which you're directing that request to. And if
Okay.
that request is submitted to a department, let's say that is not a custodian of those records, that request is then forwarded to the appropriate department to respond to.
Okay. Thank you for that additional information. So the reason I asked the question is to make sure I understood. So part of your position regarding Fulton County as the appropriate party is that even though it was submitted through a sort of maybe broader hosted Open Records Act portal, that the requester is required to identify what agency or department they're requesting that information from. And in this particular instance, the agency that was requested was not the Fulton County IT department. Is that?
That is correct. So Fulton County facilitates the portal and and grants the public and its respective departments and elected officials such as elected state officials such as the DA or the DA's office of the sheriff to use that portal to respond to open record requests.
Okay. Okay. Do you have anything to add before I call on Ms. Merchant? Do you have anything more that you want to present before I call on Ms. Merchant or counsel for the plaintiff to respond to the motion to dismiss?
Well, so that was just the update to the court regarding where we are and what has happened as of yesterday, the most recent events of this case.
Well, forgive me for interrupting, Ms. Monroe, and that's my apologies. Let me ask a very straightforward question, Ms. Merchant, and I'm not inviting a whole lot of argument. For now, obviously, you'll have your turn. Do you agree that the newest set, or I say new, but that the documents that you filed into the record as a supplement on September the 4th, docket number 67, I have reviewed those documents. It does appear to include PowerPoint attachments, which I know were a matter of contention among the parties. Do you agree with Ms. Monroe that that substantively satisfies some or all of your Open Records Act claims or requests for enforcement?
Some, but not all. And
okay.
I would disagree with them being made available 9 months ago. And
I knew that was going to be a point of contention. So that's why I'm saying what you filed yesterday clearly seems to include the PDFs that I know were an issue. Yeah. And whenever they might have been provided, you are agreeing that you've now been provided with them. And that's what I wanted to understand, is that to your mind satisfies at least some of your request. Is that correct?
It satisfies some. Yes, Judge.
Okay. So then now, Ms. Monroe, I thank you for that concise answer, Ms. Merchant. Ms. Monroe, now I will go back to you and give you an opportunity. I wanted to get to the bottom of that. Your supplement, as I understand it, was to say you think that everything's been addressed because you've now produced that last set of documents that you believed would address the Open Records Act. Ms. Merchant has said it addresses some, but not all. And so I think we probably need to forge ahead. So if you want to go ahead, Ms. Monroe.
Okay. I just need some clarification because I received an email from the merchant firm indicating that we've complied with the open records request as it pertains to critical mention records. I just want to make sure, is that still on the table or has that open records request been fulfilled?
Ms. Merchant.
like I said to the court, some of the critical mention has been complied with, not in a timely manner. And that's also, as I explained to the county, the issue is that we had to file a lawsuit to get those few documents. So there's two issues. Obviously, we don't have all the documents. There's a lot more, and I can go through that when it's my turn. But we did get those 3 documents that we were seeking: PowerPoint, media relations, bullet point, and graphs. We got those 3 documents. We got them yesterday for the first time. They were provided to us Friday for the first time in a linkable format. And we were told yesterday that the documents we were provided Friday had a hyperlink to them and we could access them. Those documents were 197 pages. The ones that we were provided 9 months ago were 44. They had all of the to and, not all, but most of the to and froms, and I can go through the documents with the court. We have them all ready to go, but definitely not provided 9 months ago. And so the only reason that they were provided was because we subpoenaed IT, which is not the records custodian. It is just the mechanism to get the records.
Okay. So I think to help Ms. Monroe focus her presentation, the reason she was asking that question, and I would like to follow up on it, is so you believe that there are still outstanding documents that have not been produced, and that the ones that were produced were untimely, which still would beg the question of the need to proceed with this lawsuit and determining who's the proper party and figuring out what to do with it. Is that an accurate?
Yes, Judge, and I can make it real simple. I have one document that I got from critical mention that I have still not received from the county. So, I mean, that's just one example that I've been asking for 9 months, the proof of payment. That's just, and I'm just using that as one example. You know, that's just one.
No, I understand. I just want to make sure I'm trying to focus our efforts here. Ms. Monroe, given that Ms. Merchant insists, I think, twofold. Number one, that that there is an issue of timeliness that will need to be resolved in the lawsuit in terms of when and whether those responsive documents were produced. And the second one is, it sounds as if Ms. Merchant continues to stand by her position that there are still responsive documents that were requested and have not been produced. So with that, I think I will ask you to please continue with your presentation.
Okay. Thank you, Your Honor. So I'll just start. I'll just address the motions to dismiss individually. And then if the court permits, we'll have it. If we do get there, we'll discuss the hearing portion of it regarding.
Well, and just to let you all know, if we do get there, I have a clear day tomorrow. So if that's what it takes, then this will roll into tomorrow to continue to get there. Anyway, go ahead, Ms. Monroe. Ms. Monroe?
Yes, I'm here.
Oh, sorry, you were quiet just long enough to make me wonder if we'd lost audio. I'm sorry.
No, I'm just getting my notes together. I'm here.
Understood. Please go ahead.
All right. So in this open records lawsuit, there are now 4 pending motions to dismiss before this court, where the motions will show with certainty that the plaintiff would not be entitled to a relief under any state of provable facts asserted in support thereof, and that the plaintiff could not possibly introduce evidence, could not produce evidence within the framework of the complaint sufficient to warrant a grant of relief sought. I'll start with the motion to dismiss for the district attorney's office. As the court mentioned earlier, the basis of this motion is merely, it's just as a matter of law that this action against the DA's office should be dismissed. For the law, it's clear that a DA's office is not an entity capable of being sued. We highlighted in my brief cases from the Myers versus Clayton matter, where the Georgia Court of Appeals held that neither the Georgia Code nor the Georgia Constitution establishes that the district attorney's office is a separate legal entity capable of being sued. Now, this holding is a general principle And the principle says that every action there must be, in every action, there must be a legal entity, a real plaintiff to a real defendant. Let us not forget that Georgia law recognizes only 3 categories of legal entities. Number 1 being the natural person, number 2 being artificial persons, number 3, corporation, i.e. corporation, number 3, quasi-artificial persons. The district attorney's office is not a natural person, nor is it a corporation, and nor is it a quasi-artificial person. Thus, for those reasons stated, in addition to the fact that district attorney's office does not fall within the definition of an agency as defined by the Open Records Act, we are asking that the court dismiss an action against the DA's office.
Okay, why not? Because as a general principle, I agree with you that the Fulton County District Attorney's Office is not an entity that somebody could sue for personal injury, or somebody could sue for employment discrimination, or anything that you might think of, or even probably a breach of contract. But there is, when you look at the definition in 50-18-70, sub B of agency, and the corresponding definition in 50-14-1, it seems pretty broad. And so why is the Fulton County District Attorney's Office, even if I accept, which I do, that it's not an entity capable of being sued for general purposes, not an agency against whom a member of the public could seek to enforce a request to provide them with public records?
Well, the simple answer to that is that the Georgia Constitution does not grant them the ability to do so. There's no legal authority within Georgia that grants them the ability to do so. Not to mention, the district attorney's office is an extension of the district attorney herself, who is considered part of the judicial branch of government, not subject to the Open Records Act as defined.
Then why, wait, so one of the reasons I'm struggling with this case is that it surprises me, and I am struggling with the argument that all 4 entities are making, that yes, we have documents, and yes, we have a procedure for asking for people to ask for them, and yes, we have a person whose job it is to provide them, and yes, we have a procedure to provide those and a portal to do so, but we're not obligated to, and no one can sue us if we don't. That strains my understanding a little bit, Ms. Monroe.
I mean, there are custodians for these agencies. They're custodians of records for these agencies. And I'm not in the position, Your Honor, and I understand your position and the complexity surrounding this issue, which is why I believe that this matter is pending before the Georgia Supreme Court to decide, because it is an issue that hasn't been really addressed head on in case law. However, there are other means in which to obtain information, public records from public agencies. I am not in the position, nor would it be in the best interest of my client, to advise opposing counsel on who and how to do that, unfortunately.
Well, I understand that, but also I think it's important to remember that while Ms. Merchant happens to be opposing counsel in this case, she is also a member of the public who has made a request for public records. And if the records are to be public, and the policy of the state of Georgia is to make public records broadly available, then to some extent it is the job of Fulton County and or the Fulton County entities that are involved here, including Madam D.A. Willis, to help a member of the public understand how to access the public records to which they are entitled, assuming they are entitled to them.
I agree, Your Honor, and it is their job. However, the question is whether or not they are subject to the Open Records Act, or whether or not they are subject to suit under the guise of the Open Records Act. And in this particular situation, we don't have a situation where documents were requested and compliance did not take place. But documents were provided. So I would understand the court's position if documents were not provided, if there has not been full transparency, if there has not been the fulfillment of a public duty, but this is not the case. This is not the case here.
Okay.
Okay, if there's no further questions by Your Honor, I'm going to move on to my second motion to dismiss.
Okay.
And this is the motion to dismiss on behalf of Bonnie Willis in her individual capacity. The open records request, or the open records request in this suit were never handled by Bonnie Willis in her individual capacity, nor was it alleged or shown in the complaint or amended complaint filed by the plaintiff. And in order for the Open Records Act to be, in order for someone to be subject to the Open Records Act, you would have to be an agency. You would have to qualify or be defined as an agency. Bonnie Willis in her individual capacity as a person does not qualify under the definition of agency in the Open Records Act.
Okay. So Ms. Monroe, how do you square that with the Milleron versus Antonikakis case? It's the Supreme Court case I mentioned a little bit earlier. It's the one they have given us so far. It was issued by Justice LaGrua, who wrote the opinion. And in that case, the specific issue before them was whether an individual, an independent contractor who was in possession of public records and was not an agency could be subject to the Open Records Act and subject to suit for failure to provide them. And the Supreme Court pretty resoundingly came down in favor that it was to be read broadly and specifically said, to the extent the trial court determined that the individual, Mr. Antonikakis, I'm sure I'm mispronouncing his name and I apologize, that he was a person to whom a request could be directed. A request for public records can be submitted directly to the custodian, even if the custodian is a private contractor, and even if the agency for which the private contractor provides services has designated an open records officer. And then it goes into some detail talking about it can be directed, that a custodian can be a person. And so even to the extent that Madam DA in her official capacity may be immune from suit, which is something we'll discuss in a moment, why is Ms. Willis not a person who's subject to a request for records under the Open Records Act?
So as I read the definition outlined in the Open Records Act and the Open Records Act, that is my basis. It is the act itself. And I understand the decision that was rendered in the case that you cited, Your Honor. However, I have a duty to I can't ignore the definition that it's within these acts that does not name a person as one who is defined as an agency.
So forgive me for interrupting, and please tell me if I'm reading this wrong, but I am on page 6 of the Westlaw opinion, which I don't know. I don't think there's a formal opinion issued yet in the Southeastern Second Reporter or the Georgia Reporter, but 2024 Westlaw 3802782, page 6 of the opinion says, as we just held, the act contemplates that a private person or entity working on the agency's behalf can prepare, maintain, or receive public records, because in view of the definition of custodian, quote, OCGA 50-18-71 B1 is expansive enough to include anyone with the requisite care and control of public records. So why would that not include Madam, or not Madam DA? Why would that not include Ms. Willis in her individual capacity?
Well, the distinction lies in that the request was not received by Madam in her individual capacity.
Okay,
So without the receipt of a request, how can one be held liable for not responding to a request?
fair enough. Please continue.
Thank you, Your Honor. In our following motion to dismiss against the DA in her official capacity, as outlined in our brief, we have here Madam DA in her official capacity is a state constitutional officer protected by the state constitutional immunity. And this immunity is an immunity that is not, that this does not disappear because of this Open Records Act. Secondly, Madam DA in her official capacity does not fall under the definition of an agency. And as outlined in my brief, we go on to talk about her role in the judicial branch of government. And because of this immunity and her judicial function, she is not subject to the Open Records Act.
So I know I sound like a broken record, Ms. Monroe, but I understand the importance of determining whether or not someone in the capacity who heads a prosecutorial agency, as Madam DA Willis does, how important it is to make sure that she is able to operate independently, which is historically why there were some concerns about providing immunity to someone in her position. That part I understand, but when you get to the statement of she's not subject, the DA is not subject to the Open Records Act, I keep falling back to, then why do you have an Open Records Act custodian who is providing open records?
Your Honor, I don't have a direct answer for that.
Okay, fair enough. I appreciate your candor. Also, in terms of Madam DA's official capacity, if it was the intention of the legislature to exempt in its entirety all district attorneys, why would that not be listed as one of the exceptions? Why would it be necessary to have sub 3 and sub 4 of 50-18-72 that specifically say, we're not going to make you produce investigatory records, we're not going to make you produce records that are created or maintained for purposes of developing a prosecution? And also, I don't believe those were asserted as objections here. I do believe sub 41 and sub 42 about attorney-client privilege and work product were asserted. But why would there be those limited exceptions if, in fact, there's no way you could ever ask for prosecutorial records or investigatory records because you can't get records from the DA because they're not subject to the Open Records Act?
Well, just because certain types of records may be subject to disclosure doesn't mean that every potential custodian of such records is subject to the Open Records Act. For example, there are plenty of judges in possession of prosecution records who clearly have no obligation to produce them under the Open Records Act.
Right, but that's because it's subject to a very specific exception.
Correct. But does it make them subject to the Open Records Act either? It's our open records suits, right? The use of the terms prosecution records is not generally applied to all prosecution officers, and acknowledging that it does include the district attorney's office doesn't render the exemption moot as a whole. Unlike the district attorney's office, there are several prosecution offices found within the executive branch that are subject to the Open Records Act, and that being county attorneys, the attorney general, etc.
Okay. So is your, I'm going to jump for a moment. Is your position, so one of your arguments about requests to Ms. Willis, and I'm only referring to her as Ms. Willis when I mean to identify her as her individual self, as opposed to the district attorney of our county. One of your arguments about the request to Ms. Willis is that there would be no basis for a litigation, an Open Records Act enforcement action such as this one, because no Open Records Act request was made to her. Is your argument the same, at least in part, for Fulton County?
Yes, Your Honor.
Okay. Regarding the county and the district attorney's office, how they relate to one another and this portal issue, who is the custodian of these records, right? The ones that are at issue and that have been requested. I assume that we're in agreement that however, whatever we call it, the custodian is someone who is attached to the district attorney's office or Madam D.A. Willis. Is that fair?
Are you asking who is the custodian of Fulton County Attorney's Office?
No, I'm asking, so the records that Ms. Merchant requested in the portal, had she, I think I understand you to say that she directed in her request that she was seeking records from the district attorney's office.
Yes.
So is it the county's position that the district attorney's office is the custodian of those records and the county is not?
So the county is not a custodian of the district attorney's office. The custodian of the district attorney's office is Dexter Q. Bond Jr. That is the custodian of the district attorney's office.
Okay. Okay. And so what I'm trying to get to the bottom of is and again, I know I sound like a broken record, and I think we're sort of getting, I know I keep pulling you off track, and I apologize, Ms. Monroe, but here's what I'm trying to figure out. I'm a member of the public, and I want copies of some document that I expect would be in the possession of Madam D.A. Willis, or the possession of the district attorney's office generically. There is a custodian, I think I heard you say Mr. Bond, is that right?
Yes.
There is a custodian, it's Mr. Bond, and I guess help me understand why it matters if it's the district attorney's office as that entity, that's how one would be identified, or the district attorney in her official capacity. Why does it matter? Why does that distinction matter? Is it solely because the district attorney's office doesn't exist in the sense of it being a legal entity that can be sued, and because Madam DA as a district attorney is immune from suit to your way of understanding the immunity provisions that would apply to an elected constitutional officer such as Madam DA Willis?
I think that's a fair representation. Yes, Your Honor.
Okay. Thank you, Ms. Monroe. I know I have picked you up and moved you around in a bunch of different ways, and I'm sure gotten you off track, but feel free to pick up where I left off or wrap up as you see fit.
Yeah, and I just wanted to provide just some more context. I did outline it in my brief, but back in 2016, the county created the Open Records portal designed to allow the public to request documents from the county and its departments and their respective custodians. The district attorney's record custodian is separate and apart from the county, as is the custodian for the county is separate and apart for the district attorney's office. Just because they use the same portal doesn't link them together, okay? The portal is just a mechanism to just make things more convenient for the public to access public records, but does not consolidate the departments or make them one in terms of who's the custodian of said records. So the county would not have direct access to those records, to the records of the district attorney's office, because again, Fulton County is not the custodian of those records. The open records portal, excuse me, it's also available to elected officials who are state constitutional officers like the district attorney. And that's, and here lies where we are. I think a lot of requesters do get very confused by this fact that because they're using the Fulton County portal, that Fulton County is, in the event there's some non-compliance, that Fulton County is on the hook. And that is not how it works.
Okay. Just out of curiosity, does the tax commissioner have an Open Records Act? Does he use the same portal? I'm just asking. I don't mean to imply that he should or shouldn't. I'm just asking the question.
Yes, Your Honor.
Okay. And so to the extent, is it fair? Maybe not exactly every single department or agency, but is it fair to say that Fulton County provides the portal for people to use to request Open Records Act documents from agencies and departments that are underneath the Fulton County umbrella or Fulton County adjacent? And then it is up to the requester to determine what specific department or agency they're requesting those records from, and then what Fulton County sends it to them?
Absolutely. And we have, and there are mechanisms where there is direct communication with the requester to guide the requester as to which department should be requesting as to where they should direct their request to, which department. Because the point is to get them the documents. If they're asking the wrong people for the documents, right, that's not transparency. That is not providing records pursuant to the Open Records Act.
Understood. Thank you, Ms. Monroe. Anything else you'd like to add? Understand that it is your motion. They are your motions to dismiss. So I'm going to hear from Ms. Merchant, and then you will get the last word because you are the movant. But if there's anything else you'd like to hear or say before I move on to Ms. Merchant, this would be your chance for now.
So that is all, Your Honor. Thank you very much.
Okay. Thank you, Ms. Monroe. Ms. Merchant?
Your Honor, unfortunately, you're stuck with me for this portion. I'm gonna handle the motions to dismiss. There are, as you can probably imagine, Ms. Merchant, as the requester, has much more information about the factual details about
Yes, sir.
that she used. So if you have questions in this portion of the presentation, she'd be the one to answer those for you, and I'll defer to her. When it comes to the actual process, the overarching process, I can speak to that because I'm familiar with that, and I am the one who drafted our brief on the motions to dismiss.
Yes, sir.
So I'm very familiar with all of the law in connection with that. So where I think we need to start, Your Honor, is to kind of trim down what I think you need to do. First and foremost, I have heard you say many times about us naming the district attorney's office as a defendant, and I don't think we need to replow that ground. So I'm going to stand on the pleadings in our prior arguments with regard to the district attorney's office motion to dismiss. I think that's adequately laid out in both of the motions that were filed, as well as our responses. So I don't need to replow that ground. I think where the rubber hits the road here is with the DA herself and with Fulton County. And I think at the 20,000-foot level, Your Honor, I think you've hit the nail on the head. The process that Fulton County put in place here is what's led to confusion, not just by two members of the bar who've been practicing 20 years and can't figure it out. Imagine a citizen who didn't have the resources or the ability to interpret this stuff the way that we can. The process itself funnels every public inquiry through the portal. The portal is managed by the Office of the County Attorney. And when Ms. Merchant initially requested these records, it was not Dexter Bond or anybody from the DA's office who certified these records. It was the custodian for Fulton County, Shalonda Miller. She is the one who certified that the records were complete, not anyone from the DA's office, and certainly not Mr. Bond at that time. So part of the issue that we're dealing with here in the context of the 12B6 is What are the factual issues laid out in the complaint, and have we sufficiently pled a cause of action regarding their compliance with the act, the facts underlying the compliance or non-compliance with the actual timeline, the 3-day timeline, and whether or not the efforts were not substantially justified that would get us to the fees portion. Your Honor brought up early on the issue of mootness, and that certainly is an issue for Your Honor to consider when it comes to the injunctive relief that we requested in the complaint. Has that injunctive relief become moot? And certainly to a certain extent with the production of these other documents, that is true. That is a true statement. And so the issues that we're litigating for injunctive purposes have been significantly narrowed down to the 4 things that Ms. Merchant, if she has an opportunity to discuss those, can walk through with these witnesses, because the critical mention documents are not the end of the story. They are the continuation of the story of us trying to get these documents now pressing 9 months. So if we take a step back, Your Honor obviously has reviewed the Gonzalez case, and you're familiar with the pleadings in that case. As you probably saw from our briefing, I tracked a lot of that because the arguments that we didn't necessarily discuss this summer are now applicable because Ms. Willis is named in both capacities. And I think Your Honor's focus on this recent decision written by Judge LaGrua is important, because I think if we step back and we look at the motions to dismiss through the lens that the legislator intended us to look at the statute through, we see that the Supreme Court and the Court of Appeals, every time they address this statute, they come down on a broad view of the law, which means if you take a broad view of the law, you're necessarily going to interpret the statute in the for instance, the word agency or whatever it may be to be more inclusive rather than less inclusive. And the cases are legion that says you interpret it in a broad, not a narrow approach, for the purpose of making sure that when in doubt, public gets access to these records. So in that context, Your Honor, I think I'd like to deal with Ms. Willis's motion in her official capacity first. That's the one, and I think primarily because I think that has a threshold issue related to immunity, which if I were in Your Honor's shoes would be the hang up I'd have in the context of a 12b-6, to be candid with you, because if she wins on that issue, which I don't think she's going to, and I don't think she should, theoretically, we don't get to stage 2. And I'll be candid with the court about that. If she's entitled to immunity, then she would be immune from suit. I don't think that's the case here. The law of immunity, as it's developed around DAs, particularly in the context of personal injury cases or civil rights cases related to damages actions against district attorneys, that's where the law has developed. And that there has never been a constitutional provision or case that says that the district attorney is immune from all actions forever and ever. Of course, if she could be sued for employment discrimination, for example, something like that, that deals with an administrative function or ministerial duty that she has to comply with the law. She's not above the law. In other words, she has to follow the law, and where she doesn't follow the law and it does not involve an issue of her discretion, she's not entitled to the type of immunity they've sought in their motion, and she shouldn't get it here.
Well, but I understand your position. One of the reasons that I kept trying to push to sort of drill down with Ms. Monroe is, do I have to reach that issue if the Fulton County District Attorney's Office is an agency / office / department / something that is capable of having an Open Records Act enforced against it, even if it is not a legal entity that could otherwise be sued?
I think that's correct, Your Honor. As long as we've got a defendant who's responsible for the records and they are properly named in the case, then I think Your Honor can avoid the immunity question as it relates to Ms. Willis. Certainly, the immunity issue is the stickier issue, one for which we hope we'd have guidance by now. But as I read the case law, Your Honor, the type of immunity they're requesting is an insulation from the suit itself. And the purpose behind the immunity, as I'm sure Your Honor is quite aware, is to not deter her from taking discretionary actions that she might otherwise be held accountable for after the fact. It allows her to do her job. So when we're looking at the immunity issue, it relates squarely to whether or not she's acting in her function as a judicial officer in the courtroom. Because it's false arrest, it's malicious prosecution, those types of things where she's operating as a lawyer in the courtroom and performing her function as a constitutional officer who's contained within the judiciary. Just because she's contained within the judiciary in the Constitution does not mean she has judicial power. And Justice Peterson brought that up during the oral arguments. There's a fine line between being included in one portion of the Constitution and whether you have rights that are enforceable vis-a-vis immunity under the Georgia Constitution. The case law has not developed to insulate her from this type of case. And the whole basis that they've raised in their motion is that this is a private right that's trying to be enforced by a private party, our law firm, against another citizen. And that's not what we have here. The cases make clear that an action to enforce this statute so that they have to comply with open records requests is a public right. It is not a right vested in Ms. Merchant individually, me individually, our firm individually. It is a public right. So the statute, and if you interpret it the way the Supreme Court has recently interpreted it in a broad manner, I just don't have a feeling that the Supreme Court is going to interpret this statute to carve out Ms. Willis. And because it's a public right of the people as a whole. And that's why we did this.
Let me sidestep for a moment. So one of the arguments that Ms. Monroe made about who is the entity and who can be sued and who would be subject to this type of enforcement action. One of the arguments that she made is that Fulton County and Ms. Willis in her individual capacity, that they were never subject to a request for records. And therefore, there's no basis for an enforcement action against them. Is it possible that the same proves true because the request was, for all intents and purposes, sent to the Fulton County District Attorney's Office? Or is your position that it was either sent to the Fulton County District Attorney's Office or Madam DA Fonnie Willis in her official capacity, to the extent that she is the umbrella over her entire office?
I don't think it matters, Judge.
Okay.
The statute says it doesn't matter. If you look at 50-1871 B1B, that provides the mechanism by which a member of the public is to learn, for lack of a better phrase, as to who they're supposed to send the request to. And that requires the custodian of the record to designate an open records officer. And that is the person, if so designated, is the person to whom the public is supposed to seek the records. That is the portal. That is what they did. And that is what we did to get the records. Whether Dexter Bond is the custodian of the record, whether Madam Willis is the custodian of the records in either capacity, or whether Fulton County is the custodian of the records, is a red herring, Your Honor. It has nothing to do with—
I understand that. I think what I'm struggling with is, as Justice LaGrua noted in the recent decision that I referenced a moment ago, we all understand agencies, entities, et cetera, can only act through their employees. And so when I'm talking about who's the custodian, I don't mean, is it Mr. Bond or is it Ms. Miller in the county attorney's office? What I mean is, does the request have to be, in order for you to enforce an action against, either get penalties for failure to comply or injunctive relief forcing compliance, doesn't that assume that you have submitted a request to the correct agency / entity / whatever? And wouldn't that mean that if you did not submit a request directly to Ms. Willis, I'm speaking of her separately from her role as the DA or her office, the district attorney's office, then doesn't that mean that she at least wouldn't be subject to an enforcement action under this?
I'm sorry to interrupt, Your Honor. I completely disagree with that.
Okay.
I disagree with that for a couple of reasons. One, we actually did submit requests, which Ms. Merchant can talk about more freely, to separate custodians, one at Fulton County and one at the district attorney's office. So we did what we could to try to do that. But more importantly, Your Honor, we are required under the act to follow the procedure that the agency sets forth for getting the records. We can't do anything else to get records other than to follow the mechanism they put in place. Because if we don't do that, we're barred from seeking an action. For instance, if we do it orally, if we call up the DA's office and we ask for something, we don't get the right to sue anybody. But they have told us how to do this, and if we don't do it that way, then we lose the right to enforce the action in the first place. So we have to follow the process they put in place, and that is the portal process. Now whether or not we later learn that some documents come from IT, some documents come from this area. Frankly, Your Honor, that is not our issue and wouldn't preclude us from seeking to enforce the action. It's up to the agency, in this case, the district attorney's office, Ms. Willis, whoever we had sued here, they all seem to fit within that hat of the person to whom we sent the request and who'd be responsible for complying. Now, let's put it this way, Judge. If we ask for different documents, let's say some of the documents, and we know for a fact now that some of the documents were only accessible in a format that we could open them and read them from the IT department. How in the world would we know that that was the person that had the right custody of that document by going through the portal? We wouldn't. So there's no way for an average member of the public to figure that out before they go through this process. So as Ms. Merchant will explain later, there were many attempts to try to figure out to whom the request should be sent, what should be sent to them, and who is responsible for complying. If you put in place a system under the Open Records Act that's so confusing that two lawyers who've been practicing for 20 years can't figure it out, what in the world is the average member of the public supposed to do? They created the process and they created the custodian that's supposed to be responsible. They become responsible, whether it's the county, it's IT, it's Ms. Willis herself, it's someone in the district attorney's office like Dexter one. I don't know who it might be, but we don't have the ability to identify those folks individually because they've set up the process that we have to follow. And
that's actually why I'm asking the question, because, for example, I'm looking at the list of individuals that you subpoenaed, and the most recent series of filings are an effort by the county to respond, file objections to those individuals. And other than Mr. Bond, who seems to be the designated, he seems to have some official designation as the Open Records Act person or the records custodian for the Fulton County District Attorney's Office. The rest of these individuals are individuals, excluding the ones, for example, like Ms. Geiger and Mr. Holmes, who are not with the DA's office. But the individuals that are with the DA's office, you might not have any reason to request specifically records that are in the possession of, I don't know, Kevin Armstrong, except that you requested some records and I guess maybe saw his name on an email or something. That may be why he's identified here. My question is, you didn't sue Kevin Armstrong, right, for not complying with the Open Records Act. And so presumably the way this would have gone is somebody would have gotten this request and the call would have gone out saying, we need to locate documents that relate to this issue. And people who would have been expected to be in possession of such records were probably asked to look, or someone looked. But you knew that Fonnie Willis might potentially be in possession of such records, and you didn't ask her directly for those records individually. And so that all I'm asking is, didn't you have to have asked her individually for records she might have possession of, public records of which she might have possession, in order to enforce an action against her, number one? And number two, aren't you, if you can sue the DA's office, because those are their public records, or the Fulton County District Attorney's Office, or Madam DA in her official capacity, do you have to sue and have relief against Fonnie Willis individually to get the relief that you seek?
Well, Judge, let me back up. I think I can answer your question, but I'll do my best. But I think what Your Honor is asking is there a requirement in the statute that we send a specific request to a specific person before a right to a lawsuit under the Act ripens? And I do not think that's the case. And we know that because the definition of agency is not specific to a person. It is to an agency or to an office. And so the person in charge of that office is the officer in charge of that office. And so to the extent there is an open records officer dedicated to that office, we would have to sue the officer in charge of that office and the office, which we have done. Imagine, Judge, imagine this. Imagine we got 40 or some pages in the initial production. There might have been, let's say, 10 witnesses, 15 witnesses identified by email in those documents. Your Honor's position would require us to send an open records request to every single one of those people. Putting aside the fact that there's no mechanism to do that in the way that they have it set up. If we were to do that, and if they did not comply, and they did not comply because they were not the one in charge of giving the documents over, or they did not comply because they gave documents to someone in the chain of command who said, I'm not giving those documents, we would be forced to sue everybody in the office.
I'm not suggesting that. What I'm suggesting is that I don't think there's any doubt that whatever we call it, you used a Fulton County portal to request district attorney records that either belong to the district attorney's office or to Madam DA Willis as the district attorney. But you never actually requested records from Fonnie Willis, except to the extent that she might have been in possession, just like Mr. Armstrong or any of the other individual employees that work at the district attorney's office, except to the extent that she might have had documents that were responsive to the request. That's the only distinction. I'm not suggesting that you have to go sue each individual employee that you think might have possession. I'm just saying that you never formally requested records from Fonnie Willis individually. You either requested them or altogether requested them from Fulton County, from the DA's office, and from the DA as an entity. That's what I'm trying to get at.
Right. And just think of, if we take that argument to its logical conclusion, Your Honor, that means that someone as a member of the public who does not know how the district attorney's office keeps their records or by whom they entrust the records, or the method or mechanism by which they collect records or save records, that would require us to send potentially dozens, if not multiple dozens of open records requests to get documents, not knowing how they're stored. So let's take IT, for example. We didn't know IT was the proper person to subpoena until recently. No one told us that. We had to dig for 9 months to figure out that we had to send a subpoena to IT. How would the average citizen, interpreting the act broadly and in favorance of disclosure of records, how in the world would someone figure that out? They wouldn't. And what would happen, and which is what happened to us for a long time, is we were told you have everything. There is nothing else to get. And Ms. Merchant will explain, and probably if allowed, question some witnesses about documents that she has in her possession that we directly requested related to forfeiture that they have told us they don't have. So I think on a global level, Your Honor, there's a balance that has to be struck in the statute between the public's right to access information they don't have control of and the open records officer's requirement to comply with the statute, knowing the records. And so I don't think the statute requires the public, the citizen, to make that distinction. I think it's up, and I think the law would make that burden placed on the person who's in charge of the records. In this case, Ms. Willis and her office, or to the extent only maintained by IT, Fulton County. And so I just don't think that the statute, the way it's written, the way it was designed to be interpreted, would require us to send a request directly to Ms. Willis in order to say she had not complied and would prevent us from an enforcement action under 73. I just don't think it would be interpreted that way. I don't think the Supreme Court would interpret it that way. And I think the policy behind the statute requires the agency, Ms. Willis, the district attorney's office, to identify an open records officer. And to the extent that there's any issue with the way the request is sent, they are to follow up and let us know, hey, that's vague, that's overbroad, or they have the right to assert objections within 3 days. So putting all that aside, Your Honor, I do think when it comes to whether or not she's subject to the act, I think Your Honor has hit on the point appropriately. But I also wanted to point out that they keep focusing on this limited definition of agency, but the act also in 50-1873A says it can be brought against persons or agencies. It's not limited to an office. It's not limited to a specific, entity. We can sue people, individuals. And I think that's important because Ms. Willis in her individual capacity, I have no idea, Your Honor, whether she was involved directly. I know historically she's very hands-on. And so I don't know if there's a policy in her office where open records requests that are sent to her office are funneled to her directly. We alleged in paragraph 22 that she should have known and probably did know about these requests and that she had an obligation to ensure that they were not destroyed. Well, at the time, we didn't know about IT, had no idea that they could actually be accessed electronically. So there's an allegation in the complaint that she did have knowledge about these requests and that she was responsible for complying with them. So I don't think that she's allowed out on a 12B6 because.
And that's that. I don't mean to beat a dead horse, right? But the reason I keep coming back to it is because I agree with you that the intention of the act and its definitions and inclusions is intended to be so broad that it would reach out and grab, agencies and individuals. But I guess the reason I keep coming back to Ms. Willis individually is that if you had filed suit against Ms. Willis and you could not demonstrate to me that you had ever actually submitted an Open Records Act request to Ms. Willis, I understand your argument is, well, I functionally did because I submitted it through the portal and they're supposed to identify the right people. But if you never served a request on Ms. Willis for public records in her possession, then you obviously, I think, couldn't sue her for failing to comply with an Open Records Act request that was never made. And so the only reason I keep coming back to that is, for example, in that case of Milleron versus Antonikakis, the defendant in that case, the records request was also made to Georgia Tech, but they specifically separately served a request on Mr. Antonikakis. Again, I'm sure I'm butchering that poor man's name. But if they hadn't, there'd be no universe in which you could enforce against him the obligation to produce records. And that's the only point I'm trying to make regarding individual Ms. Willis. Is she obligated under the umbrella of if she's got open records, public documents in her possession to produce them in response to a request that's properly submitted to the custodian? Sure. That's the only reason I keep beating that dead horse about whether or not individually Ms. Willis is an appropriate party. And I wonder if the distinction that we've not yet discussed is perhaps because of the issue of that you run into frequently with people who have these official capacities where they may be subject to immunity, right? There's this issue of, do you sue them individually or do you sue them in their official capacity? Is that the distinction? Or am I overthinking that part of it?
I don't think you're overthinking it, Your Honor. I think you're appropriately focused on the issue. I think the distinction, though, with this recent case and why they focused on the fact that there had been a request to Georgia Tech and to the contractor. I think the distinction here is if we sent a request to Miss Willis personally, it would have to go through the portal anyway. So everything funnels to the same place. That was not the case in this Georgia Tech case. There were two separate entities to which they could send the requests. There's only one here, and it has to go through the portal, and you have to choose. You have a drop-down menu. And the reason I keep bringing that up, Your Honor, is because the statute requires us to follow their process. They designate who you have to funnel the request through. And I don't think it's accidental, Your Honor, that all of these requests go through a portal. Years ago, when we sued Fulton County years ago, and I can remember at the time their open records officer saying to me, we need a process in place so I can keep track of documents that are going out of this place because I have no idea. They're not making copies. I don't know what's going on. And that's when they set up the portal. That portal was set up on purpose to eliminate documents going out of Fulton County's door without them knowing what was in there. So they created the process, and that envelops everything. that the commissioners, Fulton County itself, you know, all these individual, like as you mentioned, a tax commissioner, the DA herself, everybody is now within the umbrella of this specific mechanism that we are forced to use under the statute. So my long answer to your question, Your Honor, is I think it won't matter if we send it to her directly, because they'll force us back to the portal. And if we went back to the portal, we're left without a remedy to sue the person who may be in charge of the records under your theory. We would just have no recourse. And Your Honor is appropriately focused on the right question in terms of her individual capacity, but there's no way for us to send her, practically speaking, as a member of the public. We cannot send her a request. It has to go through the portal.
Out of curiosity, I mentioned I had looked at some of the briefing associated with the Gonzalez case that's pending in front of the Supreme Court. It was a little unclear to me. The case, the entitlement of the case is simply Deborah Gonzalez. But it is a little unclear to me in terms of the underlying facts, if the request was sent or if Ms. Gonzalez was sued as Deborah Gonzalez, or if she was sued as Madam DA Deborah Gonzalez.
So I believe, and I don't quote me, Your Honor, because I don't know the facts of that case perfectly. I know generally what was argued because I watched the oral argument. I believe that they sued her office, and they sued her in what capacity. I cannot candidly tell you that, and I don't want to misrepresent how she was named in that case. But I do believe they think she was personally involved. Failing to respond. Beyond that, Your Honor, I don't have more to offer you. We certainly can. I've spoken with the lawyer who's argued that case, and I frankly just didn't ask him that question. I was more concerned about the immunity issues and how they address those.
And it's not dispositive of anything other than, you know, call it the rule of judge's interest, other than the fact that I guess we'll eventually find out the answer to that question from the Supreme Court. So
that's right, Your Honor. He for what it's worth, he doesn't think that decision is going to come down until later this fall, perhaps October. So it's not coming anytime soon, at least in his estimation. I'm not sure why. I think perhaps with the delay in oral argument, it got moved to the next term of court, which would have allowed them more time to decide the case. I don't know, but that's my best guess.
Well, I have no idea what the outcome would be, but I would think that Justice LaGrue would be well suited to write an opinion since she's so well versed in structure and function of the statute. But in any event, go ahead.
Yes, Your Honor. I would believe that would be appropriate, but you know how they make their own calls up there. I know some of the justices were much more involved in orals than others, so that's never a good indication as to who's going to write it. But I can tell you they were hot for both sides, so it's hard to predict where they're going to go on that. I think if we look at the recent decision and how the Court of Appeals have interpreted this statute before, I think they're going to find that she's going to be subject to this act. And I think Your Honor pointed it out a little bit early in terms of how do we know that the General Assembly intended her to be subject to this act? I think we only have to look at the exception in A4, where there's a pending prosecution exception. Clearly, at the time that they created that exemption in the act, they contemplated that at some point somebody would be responsible as a DA for complying with requests for those records. And again, we're not asking for investigatory records. These are these are public records that relate to financial issues, expenditures, time off, county, that kind of stuff that have nothing to do with her role as a prosecutor in the courtroom. And so I think, if you look at the pending prosecution exemption, clearly the General Assembly, when they enacted that, contemplated that district attorneys would be subject to the act. And historically, the courts have recognized that. There's a number of cases cited in our brief where the courts have actually ruled whether or not the DA had actually complied with the request. So in practice, the courts have been operating under the assumption that DAs were subject to the act. So this argument that which would also seem to be implied by the fact that the district attorney's office has an Open Records Act custodian and routinely complies with Open Records Act requests. But yes, I mean, and this is also cited in the footnote to our latest brief. I think we raised it in the first brief as well, but they have Dexter Bond's letter that goes out actually is entitled Open Records. It signs off Open Records. It gives specific information about fees that would be charged, all the process involved in that. And so they're operating, whether or not they want to be bound by it, they are operating with the idea, and they are representing to the public that they are subject to the Open Records Act. And I think that's important because, as Your Honor pointed out very early in questioning the opposing counsel, we've named 4 people, and they are still telling you we don't have the right people. We've named everybody that we knew we could name in order to get to a broad enough level that somebody would be responsible, and now they're telling us that's not enough. So in terms of evaluating the statute's purpose, they are telling this court that as a member of the public, we are forced to go and find somebody else, not Fulton County, not the district attorney in her official capacity, not the district attorney in her individual capacity, not the office. There's somebody else. How in the world, if you interpret the statute the way the General Assembly wanted us to, how in the world does that comply with the spirit of the law? It doesn't. And the motions, Your Honor, and not to hold Miss Monroe's feet to the fire, but Your Honor asked this question, and we were right there with you. Okay, if it's not this person, then who are we supposed to name? And I think the way she phrased it, and not to hold her to this, but I think the way she phrased it is the way I've seen that, Your Honor, is they sue Miss Willis in her official capacity. Well, the reason we ended up naming her in individual capacity is right after Your Honor's hearing on that, we got an email that basically asserted substantive objections under the statute to requests that were then months old. They had told us they were not going to give us documents now because they were asserting an exemption well beyond the 3 days where they need to assert it. So that told us.
Was that the work product and attorney client under sub 41 and 42? Is that what those were, or was it something else?
Gosh.
I don't want to misstate what it was,
Okay.
and I don't have it in front of me currently, but I do remember specifically thinking they've asserted substantive objections under specific exemptions in the act that they had not done before. And that came on the heels of that hearing. And I thought to myself, well, why are they doing that?
It's right here.
And so
It's Judge, we filed it. It's Bates number merchant dash 0365. It is an open records response. It was very random. We got it July 10th, and we had gotten in that request.
Well, the reason I recall it is I think you mentioned it in your second amended complaint. And so that's the only reason I recalled that. But also Ms. Monroe and Mr. Bowman aren't double teaming. So let's stick with one at a time. Sorry, Ms. Merchant. Go ahead.
welcome to my life, Your Honor. So yeah, and I don't want to misrepresent either. The reason we sued Miss Willis in her individual capacity, if you may remember during the hearing, I said we hadn't done that because we didn't have any information that she had personally been involved in the open records requests. I made that representation to the court, and it was accurate. We didn't. And so that's why we didn't sue her in her individual capacity. It was only after that hearing when we got that email that we believed that she had been involved, and that email was a direct response to the hearing. And so, and I don't know if it came, I don't want to speculate as to whether it had anything to do specifically with the hearing or what the outcome of the hearing was. But all I know is the timing was awfully coincidental. And so our belief, and having been involved with Ms. Willis and other proceedings, our belief was that she was personally involved in making decisions about what was going in and not going, what was going out and not going out. And so because some of the requests, Your Honor, deal directly with how she was spending the county's money. And so when it comes to whether or not we've satisfied the requirements in the 12b-6, I think the complaint does that. I think the bigger issue, and one that I think the court can probably move around, is the immunity issue. But with regard to the actual 12b-6 issues beyond immunity, I think, Your Honor, if we're allowed to proceed in this hearing and talk to some of these witnesses, I think this is the picture Your Honor is going to see. You're going to see that Miss Merchant followed up almost on a 2 or 3 day week basis. She was routinely trying to get answers for why these things had not been produced. She was not unclear about it. But I think you're going to see the initial request was not responded to within 3 days. They sent a generic letter initially that said, hey, we got your request, thank you, which is under the act a non-response. under the act, within 3 days, they have to tell us whether they have responsive documents and whether or not they're going to withhold any of them based on some exemption in the act. They did none of that. So the 3-day requirement ran without their compliance as an initial matter. So that has to do with whether or not we crossed the hurdle into whether they were substantially justified in not complying with the statute. I think the evidence that you're going to hear from these witnesses is one, that they still have not given us documents after 9 months, despite repeated requests to do so, that they have intentionally stonewalled Ms. Merchant by not providing adequate electronic links for the documents, and by not doing the appropriate searches for the documents, which is an issue we raised with the court last week. They're all over the place, Your Honor. The evidence is going to be that sometimes they certify documents as complete by one witness, and then we'll get other documents from a different witness that should be included in the certification from the other witness. And it goes all over the place. I don't pretend to know the details. I've watched her work, so I know that there is a lot there, Your Honor. And in the context of a 12b-6, what I'm suggesting to the court is these are issues that can only be resolved through testimony. And in a normal course of events, because this is a civil action, we'd be in discovery. We'd send document requests and we would take depositions. And that has happened. Historically, when Open Records Act cases are filed, there is a discovery process. Just like there is under the Civil Practice Act, we'd be entitled to serve document requests and take depositions to clear all this up. We brought the witnesses today, Your Honor, and hopefully we'll have a chance to speak with them today and tomorrow so that Your Honor has an understanding of the facts about these requests so that they're not amorphous, that you understand very concretely what efforts were taken to get them and what efforts were made to stonewall us. Because I think that dovetails entirely with the whole purpose of the act and the enforcement action that's set forth in 73. This is the only recourse we have, Your Honor. That the way that they have set the process up, there's no way to negotiate to get the documents. They force you to file a lawsuit. They leave us with no choice. And so if they're going to do that, then there has to be accountability for it, and an accountability for not providing records when the public asks for them that are clearly public records and for which they made no objection in a timely manner. And now they want to continue to try to stonewall us. I don't want to say it's in an election year, but we're in an election year. And the delay that's happened in part due to me not naming the right people to begin with, we're right up against an election and we're still seeing documents come in that Ms. Merchant asked for in January of this year. Some of which they claim they don't have, like a pamphlet involving a flyer about, they said they don't have records, Your Honor, for a very concrete example. They said they don't have records as to the number of lawyers they have employed in their office and when they were hired. We asked for information specifically about when lawyers were hired and the number of lawyers on staff. They have a whole pamphlet, has a photograph of the DA's office that they use public money to pay for, and they tell us with a straight face they don't have any information related to who they have on staff at any one point. We know that's not true because they have to pay them. There are payroll records. So it's just one concrete example, Your Honor, of how, and I think Ms. Merchant and I were talking about this, I think part of what's going on here is there's been no accountability for these people, that people give up. They quit because they've made the process so hard and so burdensome on the average citizen that they don't have the time or the resources to fight. And so the 4 motions to dismiss are the latest example of that, Your Honor, that they'll stop at nothing to make sure we can't get a clear understanding of what they have and don't have, and if something has been lost or destroyed, when that happened. I think if Your Honor's inclined to deny the motions, I think you will see through these witnesses the pattern of obfuscation that we know has occurred. For all the reasons that are put forth in our brief, we don't think she's subject to immunity, and or the defendants collectively are subject to any kind of immunity, and we think they're all subject to the act. And we think they're all proper defendants because of the way they have set the system up. We have no choice but to sue everybody. And we didn't want to do that. That's not our hope and prayer every day when we wake up. We have over $1,000 in costs that our firm has expended on this case to get it filed, to serve witnesses, to get the lawsuit itself served, all sorts of case expenses for subpoenas. All of this stuff adds up, Your Honor, and the average citizen probably wouldn't do it. We're left to try to uncover what's going on here. And so, unless Your Honor has additional questions related to the legal piece on the 12B6, I will add one thing, Your Honor. I think if Your Honor wants to convert this motion into a motion for summary judgment, I think you'd be entitled to do that and hear the evidence. I think under under 91156, we as the plaintiff would be entitled to 30 days notice and be able to respond to it. But we waive that, and let's press on. Let's hear the evidence. Let's hear the testimony. And then Your Honor can make a ruling in the context of a more complete factual picture than trying to resolve this thing as part of a dispositive 12B6. So
Okay.
for all those reasons, Your Honor, we'd ask that all 4 motions be denied.
Thank you. Ms. Monroe? If you would not mind, I am going to take about a 5-minute break and then come back right at 4 o'clock and then let you have an opportunity to reply or rebut. Okay?
Thank you, Your Honor. I was just gonna mention that was actually Ms. Monroe was just forced to take a similar break, so.
Sorry, understood. So we are going to be in recess for about the next 7 minutes. I'll be back at 4 o'clock. Thank you.
Thank you, Your Honor.
figured it out. I thought a lot of that. the 2 PM hearing that they're just recess. Supposed to be back by now. It's a Zoom, it's the judges here, but it's most of it's conducted by.
I'm not here. Where's the deputy?
She was here, I'm not sure. Or she might have some time. Again, they're, yeah.
What's up, Lou? What's up? What's up? What's up? You here? No. Me neither. I'm just going to work. What y'all doing? Anybody there? No. All right, I'm not listening. I'm just walking through. So what is the? Because I was just walking through and I said, where's the baby? I was like, where's something? I'm practicing.
Well, because sometimes like Judge Bentham has taken to leaving her lights on, so sometimes you don't know if people are here or not here.
I'm not here next, Judge Williams not here, so you won't.
Oh,
Yeah,
I appreciate it, because I will be here.
Okay. Counsel, I apologize. I'm a little past when I said I would be.
Of course, Your Honor.
Ms. Monroe,
Yes, I am here. I'm sorry, I had to.
great minds think alike. I needed a break as well. I just didn't get to it fast enough. So, but right before I took a break, the plaintiffs had concluded their argument. And so, as I said, I would give you the opportunity to respond, since it is your motion, you get the last word.
Okay, thank you. So just a few things that I wanted to respond to. Plaintiff has been saying this ongoingly, that because of the mere use of the portal, that it basically attaches liability to everyone in Fulton County, even leading up to the Board of Commissioners, as a result to a violation of the Open Records Act. And that because this is the only means in which to submit an open records request, everyone's on the hook. That is completely erroneous. The portal is simply a mechanism. It's simply a means in which that was put in place to help the public access information regarding government. It was merely to increase the public's ability to get information. The Open Records Act was never created to be adversarial. The sole means of the act was to help the public obtain more knowledge on how their government is being ran. Now, the way that plaintiff wants us to utilize the Open Records Act, he wants the public to use the Open Records Act as a vice to attack, a vice to harass, a vice to, if you don't do this, then I'm going to sue you. That's not what the Open Records Act was designed for. This was not the only way in which to submit a open records request. There's multiple ways in submitting open records requests pursuant to the statute. You can submit one by email. You can submit one over the phone. You can submit.
Well, not really. I mean, if you submit one over the phone, I think I understand that you don't have the same rights and remedies to enforce it, number one. And number two, if like Fulton County has done, or maybe the district attorney's office has done, or maybe different departments, if you designate a records custodian, then in order to take full advantage of the enforcement mechanism, if those records aren't produced, aren't you required to submit it in the way that they want it submitted?
You can submit it by fax. You can submit it by email. So there's multiple ways in which to submit an open records request. You do not have to use the portal.
Right, I understand that, but doesn't that to some extent limit the enforcement rights that a person who submits a document not using the portal might have?
No, absolutely not. Absolutely not. If it's only a verbal request, that's where the limitation lies. But if it's in writing, there is no limit. Also to, excuse me, as I review my notes.
I understand.
All right, and as it pertains to sovereign immunity, unless it's explicitly waived, the immunity lies. We can't do away with the immunity for the broad application of the Open Records Act. I do believe that because this issue, as it pertains to the Open Records Act, is a novel one, and which is why it's pending before the Georgia Supreme Court, why there are so many questions here. But we cannot supplement what the law is for our thoughts and our opinions as to how it should be applied. And that's what plaintiff wants us to do here.
So I have a question. When we were talking about the different ways that one may submit a request, let's see, OCGA 50-18-71 sub B1A, I'm sorry, B2. There we go. It talks about an agency designating one or more open records officers to whom requests should be submitted. Has Madam D.A. Willis and or the Fulton County District Attorney's Office followed that procedure to designate one or more open records officers upon whom requests for inspection and copying may be delivered?
We've identified the custodians for both Fulton County and the District Attorney's Office.
I'm not sure that you're answering the question that I asked. I understand that in the process of this litigation, it has been identified that Mr. Bond is an open records person. He's the custodian of records and serves in some open records capacity for the District Attorney's Office / Madam D.A. Willis. And I also understand, I think, that Shalonda Miller with the Fulton County Attorney's Office operates in some capacity for the Fulton County requests. But my question was, the statute that I was referencing says an agency that designates one or more open records officers upon whom requests for inspection may be delivered shall make such designation in writing and then provide notice, and you have to file something with the legal organ of the county. And so my question is not, have you identified them in this lawsuit? It was, has either entity, the county or whatever entity, Madam DA, et cetera, followed that procedure and designated an open records officer?
For the county, I believe, yes. I don't know for sure. I have seen things in writing concerning the county, but for the District Attorney's Office, I am not sure.
Okay, thank you.
I believe plaintiff went into a lot of the substantive matters in addressing the motions as it pertains to the actual requests themselves, the list of hirings, a brochure with a picture of Madam and some of her employees. I mean, that I would like to reserve my response to those allegations if and when we proceed to an actual hearing on the merits.
Right. And I think that's fair, Ms. Monroe. In fact, one of the questions I was about to ask, to the extent that it sounds like we're sort of wrapping up, is towards the end of plaintiff's counsel's argument, there was a discussion about, what to do with the case should the court deny any or some or all of the motions to dismiss, such that something would proceed. And then we would need to get into the merits of the actual requests that were made and the extent to which these witnesses have information about the extent to which the Open Records Act requests were handled by the entities. And so one of the questions I have is, I think I understand that the reason these witnesses were produced today, or, subpoenaed for appearance today, in the event that I deny the motion to dismiss to any or all of the entities, is that the defendant's argument is none of these entities are the right entities. But the backup argument is the requests are moot because we've produced all the documents. And to the extent that that forms a basis for dismissal, then is it appropriate for the court to hear from witnesses who may or may not, or at least allow the parties to examine witnesses who may or may not advise that there are all documents have been produced or not? Or am I exceeding the authority that the court should exercise under 12B and converting it into a summary judgment motion if I hear from those witnesses. And so to clarify what that was a really long-winded question, if I hear evidence, I don't wish to hear evidence about the substance of these documents or why they were requested, which isn't relevant, and all this sort of stuff. It's really about what efforts were taken to locate and identify, and what assurances are there that all the documents were produced, which is an argument to defeat the claim on the basis that the claim is moot. What are your thoughts on that procedurally, Ms. Monroe?
Thank you for asking, Your Honor. I think procedurally for this to actually to honor the rules of civil procedure, I think it would make the most sense to rule on the motions. Once we have a defendant to proceed, then we can then, if it's in the court's discretion, move to discovery. If not discovery, then straight to a hearing with the proper defendant of the court's choice.
Okay. I'm going to briefly ask counsel for the plaintiff if you want to respond. I mean, you mentioned this concern. I understand that I can, if you're willing to waive notice, can sort of hear that evidence now, but I mean, it really is. I'm just wondering if it's going to be too difficult to separate these things out in terms of the substance of the requests that were made, separate from the efforts made to locate, because the types of documents that might exist is a different discussion than what reasonable efforts did you undertake to locate documents that might be responsive to the request, which does go to the issue of mootness, which is part of the motions to dismiss.
Yeah, Your Honor, I mean, the strict tenets of 12B6 say you're confined to the four corners of the complaint.
Yep.
I have to concede that because that's the
Yep.
truth. So if Your Honor wants to hear any evidence that's not in the complaint or the second amended complaint or not attached to the complaint, you're going to have to either allow evidence on the motion, which would then presumably convert it into a Rule 56 motion, requiring notice to us, which we've obviously waived. We intended, based on Your Honor's instruction, to question these witnesses about the very things that you have talked about. So the presentation of the evidence is geared around the efforts they took or did not take, and what issues are still outstanding with regard to at least 4 requests. So that is the focus of the inquiry, and I do believe it is tied to the motion to dismiss issues. But I think if you go beyond the 4 corners, you're going to convert it into a different motion. On the other hand, you could simply deny some or all of the motions, which would then allow us to vet the issues in discovery. And to the extent the county or anybody else who was left in the case, any issues with the scope of discovery, it would proceed like a normal civil case.
Okay. And then thank you. And that directs me back to Ms. Monroe. Let's assume for a moment that the court, that one of the defendants is going to remain in this case as a potentially appropriate defendant to seek to enforce Open Records Act remedies against. What is your suggestion for dealing with the mootness issue in terms of either allowing for some very brief discovery period or scheduling a substantive evidentiary hearing at a fairly close from now, but later in time, date to discuss the substantive issues of the documents and the efforts undertaken to comply with the Open Records Act? What are your thoughts on that, Ms. Monroe?
Sorry, I was on mute there. So the portion of my motion that does talk about, that speaks to mootness, wasn't inserted as part of the motions to dismiss, but as a second part to this proceedings, which goes to the merits, to say, in the event that the court finds that the defendants in this case should not be dismissed from this action. And this was only pertaining to, I believe, the district attorney's office. That was only found in the motion to dismiss for the district attorney's office, not in the other motions. That was just to basically be addressed in an evidentiary hearing. But the goal was for the court to rule on the motions as to who would be the defendant to be sued or dismiss the complaint altogether. But assuming that the court were to find that there was a defendant, a defendant liable under this action, and that was a defendant that was named in the caption, we would then proceed, once the ruling was made on my motions, to an evidentiary hearing if the whole action was not dismissed altogether. If that makes sense. I don't know if I'm being clear.
It does. No, I understand your position. But the next question then is, if the court were to, again, let's assume for a moment that some defendant is going to stay in this case.
Mhm.
What is your preference or suggestion about what to do next? Would you, really the options are some expedited brief discovery period, and or a fairly expedited, soon to be scheduled in the near term, evidentiary hearing to address these issues, or both. Any or all the things that y'all pick and that I decide on, or I'm telling you going to be expedited because that's how the statute is designed.
Right.
But my question to you is, what is your preference? And what, if it's a discovery period, what do you think is a reasonable time period for that?
So no, this is a very straightforward case, in my opinion, so I don't believe discovery, there would be any need for discovery. So it would be my preference to just move forward on an evidentiary hearing in the event there is a defendant that would be held liable under this action.
Okay. Miss,
Your Honor,
Yes.
may I jump in quickly?
I was just about to call on you, so yes, please.
Okay, so I think one wrinkle here is I think Your Honor has the ability today to rule on the motions. And if Your Honor does that, then
I intend to.
Yeah, then two things happen. The automatic stay that's set forth in 911-12F goes away.
Right.
So once the stay is lifted, then Your Honor would have the ability today and tomorrow to hear the evidence. The hearing, our concern, Your Honor, is that based on the history, that as soon as we attempt to conduct any discovery, whether it's 2 weeks of discovery, a month of discovery, there are going to be motions filed that prevent us from accessing information from witnesses. Whether it's going to be a motion for a protective order or some sort of motion under 911-37, I don't know what it might be, but it's going to delay the proceedings. So I would caution Your Honor, if the court is inclined to move with some speed here, and that
I am inclined to move with speed. I only inquired about discovery because I didn't know the extent to which either party was interested. It sounds like Ms. Monroe's response is that she thinks an evidentiary hearing is the better course, and it sounds like you do as well. So I think that addresses that issue.
Yeah, and I do want to just highlight, Your Honor, I think the issue of mootness has been introduced today through counsel. I don't think the issue of mootness is relevant for purposes of the 12B6 motion because the complaint as it stands without evidence says that they have not complied with the law. They have not complied with the statute. That is accepted as true at this stage of the proceedings. So to the extent that she's arguing outside the pleadings that some or all of these claims are now moot, I get the practical piece of it. We have alleged that they are not moot. in some form or fashion, and that a lot of these requests are still outstanding. So the issue itself, as pled in the complaint, is sufficient to defeat the motion on its face. So we would just, our preference, Your Honor, in terms of timelines would be for Your Honor to rule today, or as soon as practical, since we have the witnesses here, perhaps bring them back in short order to proceed, because I think the parties agree the issues are fairly narrow, but still contested.
Understood. Ms. Monroe, anything to add on that issue?
I have nothing to add, Your Honor, nothing else.
Okay. Okay, so as I have, I think, made pretty clear, I am somewhat frustrated by the idea that there are 4 defendants and none of them are somehow responsible for producing documents, despite the fact that some documents have been produced. And clearly there are people whose job it is to receive these requests and process these requests and attempt to secure discovery. I'm sorry, attempt to secure requests, the responsive information. So here's what I am left with. Again, I will say how much I would love it if the Supreme Court had given me the answer, because as it stands, I'm going to give you the answer I think is appropriate, and the Supreme Court may tell me I'm wrong in any moment. So, there's that to look forward to. Having said all of that, I think I've made very clear, I understand the effort at the distinction, but I struggle to see how I struggle to see how Fonnie Willis individually is an appropriate defendant here, because she was not served. I understand that she received internally probably requests. She was not served with a formal request for records that she was in possession of, other than to the extent that the Fulton County DA was served with a request. And so I have real concerns about that. And I understand the import because of the concern about immunity that potentially attaches to Madam DA Fonnie Willis. But I think there's a distinction for a reason. And so I am going to grant the motion to dismiss Fonnie Willis in her individual capacity. Having said that, however, I am denying the motion to dismiss Fonnie Willis as the DA, and I'm denying the motion to dismiss the Fulton County District Attorney's Office, and here's why. Number one, as to Madam DA Willis, the district attorney, I agree, has some broad immunity that attaches. But I agree with the plaintiffs that the traditional understanding of immunity that attaches to a district attorney was not intended to limit or inhibit the public's right to access non-prosecutorial documents, non-investigative documents that are held by the district attorney. And I think that if the legislature had intended so, it would have exempted district attorneys generally, and it did not. And so for that reason, I'm going to deny the motion to dismiss as to District Attorney Willis. I am also going to deny the motion as to the Fulton County District Attorney's Office. And I do that with the most hesitance because clearly the Fulton County District Attorney's Office is not a legal entity that can be sued in any capacity. However, I don't think there's any way to read the Open Meetings Act provisions that are adopted by reference in the Open Records Act provisions without understanding that the Fulton County District Attorney's Office is an office, agency, department, etc. of Fulton County or of the state, and therefore would be subject to the Open Records Act requirements. As to Fulton County, I do have concerns, as Ms. Monroe pointed out, that any ruling that I make be understood as overly broad in the sense that any request submitted to any department of Fulton County using its portal somehow makes the entirety of Fulton County responsible. And that is definitely not going to be my ruling. However, to the extent that Fulton County hosts the portal and is clearly subject to the Open Records Act, particularly here where the agency and the officer are denying that they are subject to the act. The county clearly is, and the county is hosting the method to request and receive responses, to submit requests and receive responses and responsive documents. And so to the extent that the county is doing so in the absence of the records custodian, i.e. the district attorney in her official capacity, or the Fulton County District Attorney's Office, such as it is constituted for purposes of it being an agency or office, the Fulton County stays in the case as well. So that's going to be my ruling. I am, as I said, I'm granting the motion to dismiss as to Ms. Bonnie Willis. I'm denying the motion as to the other defendants. Mr. Merchant, can you please provide me with a proposed order that I can edit regarding my rulings in this case?
I sure can, Your Honor.
Ms. Monroe, can you please provide me a proposed order granting the motion to dismiss as to Ms. Willis? And again, I don't mean to be disrespectful. She's entitled to that title. I'm only doing that to distinguish her in her individual capacity.
Yes, sorry. I'm sorry.
That's okay. Thank you. I apologize. So one of the things, sometimes no answer is an answer. And so some of the email traffic that I've received over the last few days is, wait, what about these witnesses? What are we doing? And the choice to have the witnesses available was intentional. And so that means I owe those witnesses an apology for holding them up today to the extent that they are here and have not been called upon to testify. And so as of today, they are released, but not indefinitely. It does not sound as if anyone needs or wishes to have any sort of discovery period. The Open Records Act is intended to be an expedited process because it's intended to allow the parties to obtain the documents that they are requesting. And so it is my intention to expedite an actual evidentiary hearing regarding the efforts that were undertaken, the nature and scope of documents that might exist, and what efforts were taken to locate such documents that would be responsive and in the possession of the Fulton County District Attorney's Office, Madam DA Bonnie Willis, and Fulton County to the extent that no other entity is subject to the act. That's going to be my ruling. I believe in the interest of expediting, I was originally set for a trial week next week, and I believe it's been indicated to me that many of those parties' cases are going to resolve. And so I may be in a position, I know when we start talking about witnesses and it's a lengthy list, but if we're talking about limited, trying to focus our examinations, realistically, any idea of how much time you think you might need to examine witnesses, Ms. Merchant?
A day, Judge. I think we could do it within a day.
Okay. Ms. Monroe, do you agree with that?
Yes, Your Honor.
Okay. So in looking at my calendar, assuming that my cases resolve as I expect them to do, I am wide open on Thursday, the 12th. Wait a minute. Yes, I'm open on Thursday, the 12th. I'm open on Friday, the 13th. for all the fun that day carries with it. Again, assuming that those cases resolve on Monday and Tuesday, I'm actually available. I can move things around and be available on Wednesday, the 11th as well. What are y'all's thoughts? Is that too soon? Do we need to move it? What do we think? Mr. Merchant, Ms. Monroe, or Ms. Merchant, Ms. Monroe?
So I have a pre-scheduled CLE for the 12, sorry, for the second, sorry, this week that's coming up.
The week of the 9th?
So the week of the 9th. So, and then also for the 16th, 17th. The week of the 16th it's a better week for me. So if plaintiff is available during the week of the 16th, we could do it for the 19th. Oh, sorry, I have a mediation on that day.
And Judge, we're available. You said the 12th and the 13th were available both of those days.
Okay, I also, it looks like I'm available on the 16th.
We're available.
Ms. Monroe?
Yes, the 16th looks like it's open, yeah.
Okay.
Hey, Your Honor, I think we spoke too soon on our end. I've got depositions all day on the 16th.
Okay.
If we could move it to a different day, that would be.
17th.
I don't know Your Honor's availability, but does the 17th work?
No, I have a giant criminal calendar that day. Actually, I have about 4 giant criminal calendars that day.
18th.
Here's the best I can do. I am tentatively available the 18th and 19th. The 19th would be better. If that will work for the parties.
The
We can
19th
do
works
either
for me.
date.
Yep, 19th is great, Your Honor.
That's perfect, Your Honor.
Let me look one more time to make sure I'm not going to go back in my office and my litigation manager and staff attorney are going to yell at me that I'm wrong. That I do have something that day. Let me look again. Yeah, it looks like I'm open the 19th and 20th. The only caveat to that, and I would give you as much notice as possible, would be if I am set to start a trial, if it goes into the 19th and 20th, we might have to get creative and move things around. Now, one of the other reasons that I wanted to revisit the issue of conducting an evidentiary hearing is that generally speaking, I love Zoom. I think it's very effective. It allows lots of people to be in multiple places where they need to be instead of being stuck in traffic and that sort of thing. But for an evidentiary hearing, I find that it gets a little clunky when we're trying to call witnesses to the stand and present documents, et cetera. And so I typically prefer to have those, especially when it's, more than a few documents, more than a few witnesses in person. And so I think what I would likely do is notice this for the 19th at either 9 or 9:30 a.m. And it would be an in-person hearing.
Perfect.
That's fine.
Now, to the extent, I understand there's been some disagreement about that, but to the extent that the parties can consent to having any witnesses appear by Zoom because it's more convenient for those witnesses, I encourage you to do that. If you cannot agree, I will rule based on whatever information y'all have about the nature of the unavailability or the need to appear remotely. And I will rule on that, but I strongly encourage the parties to see if they can agree. And we will go from there. Okay. Anything else that the parties need from me? One more thing. I would like to have those proposed orders. I know I'm asking for them on an expedited basis. But I would like to have them sooner rather than later. As I'm sitting here looking at my calendar, if I could have them no later than say the 12th, which is a week from now, if you can get them to me sooner, great. But if you, I will ultimately end up entering one order that will rule on it all together. But if you can get me your drafts, by the 12th, I'll make sure that there is an order on file as quickly as I can. So there will be an order on file prior to, the hearing, although I am going to go ahead and issue a hearing notice for the 19th. Anything else that you need from me before we adjourn, Ms. Monroe?
Yeah, yes, Your Honor, one housekeeping matter, you've.
Hang on, sorry, I actually asked Ms. Monroe.
Oh, I'm
So-
sorry.
That's okay. Ms. Monroe?
That is it, Your Honor, nothing further.
Okay. Mr. Merchant, anything else?
I'm so sorry to interrupt. I
No.
wasn't paying close enough attention, but one housekeeping issue is, Your Honor's released the witnesses that we had subpoenaed for today.
Yes.
Can we have an order from Your Honor that they will reappear? At the-
Yes, and that's why I said that, I tried to say that carefully, that they were excused for today. But it is my intention that, I mean, they've been subpoenaed, and so to the extent that we are continuing this matter to the 19th, I'm not expecting that you have to reserve them with subpoenas.
Perfect. Thank you, Your Honor. That's all we have.
And the same would apply to any witnesses that have been subpoenaed by the defendants.
Your Honor, if I can just clarify that one point or address that one point of concern. So there were subpoenas for the production of documents, not subpoenas for the production of testimony witnesses. So they're two separate things.
Were they subpoenas to appear at this hearing?
At this hearing, there was no scope provided for the type of testimony of what that witness would be testifying to, which lies a question whether or not it was a proper subpoena. It on the top, it's literally labeled subpoena for production of evidence. And so once the business certifications are submitted, there is no need for the witness to then appear. The business certification serves as that witness's testimony and also is supposed to lay that foundation for getting the evidence in versus having in lieu of having the person come in with the documents at hand, laying the foundation in person in court. That is my understanding of the law.
Okay, so
Mhm.
let me interrupt you for a moment. So, I mean, we can have a disagreement. Y'all can have a disagreement about this if that's what we need to do. I agree with you that the subpoena says the subpoena for the production of evidence, but it requires the presence of the witness no later than September, to appear at September 5th today at 2 p.m. I understand that there is an attachment saying, please produce certain documents, and that those individuals have appeared, have filed a response/objection that purports to provide certain documents and purports to certify those documents. The dispute arises, and that's what there was email traffic back and forth about, is that the plaintiffs believe that there may be that they have evidence that would indicate that perhaps the certifications that those are all the records is an incomplete or not entirely accurate certification. Now, ultimately, it may be that one entity has something that the other entity didn't have anymore because they weren't obligated to keep it. There are a million reasons that might be the case. But I think I understand that the merchant firm has indicated that the reason they wanted actual witnesses was because there is a dispute about whether or not those records are all the records and what efforts were made to identify additional records. Now, I believe that's a fair inquiry for the plaintiffs to make at a hearing. If you're going to insist that they be resubpoenaed, then I guess we can insist that Mr. Merchant resubpoena all those witnesses, but that's just going to add to the costs associated with this case. And that seems unnecessary if it can be avoided. But that's just my opinion.
If they could just provide, so, because I need to be in the best posture to defend this case. So if they could provide a list of witnesses in which they plan on calling at the evidentiary hearing, and what they plan on questioning them about, the scope of that testimony, that would be.
Well, I would encourage the parties to have a wholesome conversation about how that might happen, if only to encourage efficiency. But I will also point out that this is not a 30B6 deposition. They're not technically required to identify areas of inquiry. They are limited by the scope of the lawsuit. So it's not as if they can ask, these witnesses about things that don't have anything to do with the Open Records Act requests that were submitted to Fulton County. Now, again, just because I'm saying I'm not going to compel them to provide you with a witness list because of the reasons that I've just said, or to particularly identify areas of inquiry that they might pursue, doesn't mean I'm not strongly encouraging the plaintiffs to limit the witnesses and the scope of necessary witnesses as much as possible, and to work in good faith with the defense counsel to help them be ready so that we can have an efficient hearing. Yes, I'm strongly encouraging that.
Yes, Your Honor, we will certainly.
We'll do that.
Okay.
And yeah, Your Honor, I would say I think we all recognize it's probably in everybody's interest not to have a bunch of motion practice, so we will do everything we can to resolve that and agree on.
Thank you.
Get our witnesses in order.
Thank you, Mr. Bowman. I appreciate that. I believe that concludes this matter. Anything else, Mr. Merchant?
Nothing from the plaintiff, Your Honor.
Ms. Monroe?
Nothing further, Your Honor.
Thank you so much. All of you have a good time, a good day. I will see you I'll see you on the 19th. I'll send out a notice and I will look for your proposed orders. Thank you all.